Support comes from St. Louis Public Library Foundation, helping the library serve children and their families with programs and services needed to become lifelong readers. More information about the foundation is at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Missouri has new congressional maps, but they face multiple legal challenges. Do any have a chance at stopping this scheme to gerrymander the state for Republicans? And a Palestinian student group had to sue Mizzou after being barred from its homecoming parade. They won, but what does the First Amendment say about their rights to participate, and how? And Missouri's new squatters law is under fire. It seemingly gives landlords the right to evict without any due process for tenants. Can that possibly hold up to legal scrutiny? These are big legal questions, and so today we have three great lawyers to help us answer them. Yes, today is our monthly Legal Roundtable, and joining us to lend his expertise today is Booker T. Shaw. He's a former justice on the Missouri Court of Appeals, Eastern District, and now a partner at Thompson Coburn. Booker, welcome back.
Glad to be back, Sarah.
And we're also joined today by Jim Wersch. He's a former public defender. He's now in private practice as a founding partner at the law firm Kazali Wersch. He specializes in civil rights litigation. Jim, welcome back.
Thanks for having me.
And today we're also joined by Nicole Gorofsky. She's a former prosecutor in both state and federal court, and she is now a partner at the Clayton firm Frankel, Rubin, Klein, Payne, and Podlowski. Nicole, congrats on that new job. That's quite a mouthful. I hope I got that right.
You did, and I'm glad to be here.
So we have a lot to talk about today. A lot of it just seems to be very political, but let's face it, the law and politics seem to collide a lot these days. Everything ends up in court. Governor Mike Kehoe signed a bill into law this past Sunday. This creates a new congressional map, and it seems like whether that map becomes reality for Missouri's voters is up to judges. There have been several lawsuits filed challenging this bill. One of them deals with an apparent typo in census data that leaves voters in one Kansas City neighborhood. They're seemingly assigned to two different congressional districts. The other says the legislature simply did not have the right to draw new maps now. Nicole, Democrats are really getting their hopes up in the court system. Would you give either of these legal arguments any chance at success?
Well, so I kind of want to start with a small history lesson. So about 6 years ago, in the United States Supreme Court, there was a case called Russo versus Common Cause, where I think most people would probably think before that gerrymandering for political reasons would be completely unconstitutional and that you couldn't do it. Well, about 6 years ago in this case, in the United States Supreme Court, the Judge Roberts' court, and as you can imagine, the decision was split on political lines. The court found that political reasons for, redistricting is not necessarily forbidden. So that's kind of confusing, which explains a little bit why we get these lawsuits that are coming at it from a totally different angle here, because they can't just file a lawsuit against the gerrymandering issue in Missouri by saying, oh, it's drawn on political lines.
And that might have been an argument maybe even 10 years ago.
Correct. So now we have these lawsuits. We have one by the NAACP that basically says, well, the governor called a special session to do this redistricting and wasn't entitled to call that special session, so we're attacking it on that ground. Then we have another lawsuit coming at it from a different direction saying the map isn't drawn properly. Then we even have sort of Chuck Hatfield coming at it from a different direction saying, I don't care how the map is drawn. They just don't have the authority to do this at all. So, and that's because he says the Missouri Constitution only lets you redraw maps after a census. So that's why we have these kind of strange ways of coming at these legal arguments.
Yeah, and there's a lot of legal arguments happening here. And Booker, part of what I get confused about is, what if you have one judge who's handling one of these things and he goes, yep, these maps are good to go? Can some other judge be like, oh, no, I've got this other matter. These maps are done for?
Yeah, you could have that happen. There could be some inconsistent rulings here, but ultimately this is going to likely be fast-tracked to the appellate court, whatever happens. So that wouldn't be unusual. It could happen.
So you're a former appellate court justice for Missouri. This would end up in the court maybe that you used to be in, or maybe another branch of that court.
Yes.
Do you have any sense of what you think might be the strongest argument here for people who are trying to stop these maps?
Well, I think, as Nicole has pointed out, the more difficult argument, in my opinion, is to say that there is some racial disparity. Because the Supreme Court has pretty much said that as long as there is some viable or arguable political reason for doing so, then the racial disparity argument fails. So then you have to look at the timing of it, the 10-year issue, and the overlapping district issue that may violate the one person, one vote Reynolds versus Sims decision. So I think, practically speaking, those two arguments are likely the better argument.
Okay. So when we as journalists found out that there was this voter district, that it appears that there's two different voter districts that have the same name, and this map relies upon them, all of us journalists got very excited because we're like, whoa, this is something that sounds like this is a big screw up. Jim, what's your sense? Is this a big screw up, or does it only feel that way when you don't have a law license?
Well, it's a screw up, and it's not surprising when you rush something through. The General Assembly, often when they're rushing bills through, gets sloppy, and so they did something and it was sloppy. Whether or not that's going to be something that's going to sink this thing, I don't know. I mean, it's something that I could see as a judge being fixable, just saying, well, we're going to put this group in one or the other, and do the spirit of it.
So the judge could theoretically just move those voters and say, hey, this is just a typo. I'm just going to cross this T here.
Could be.
Could be. Former appellate justice. Is that something you could theoretically see an appellate court doing?
You could see it. We could see any number of things, so I wouldn't rule it out. I just go, well.
Yeah. Nicole?
I mean, so I think the first issues to get to are whether or not you can even do this at all. So whether or not the special session was okay, whether or not you can do redistricting at all, then I think we get into the maps and whether or not the courts are actually going to get into the maps and how they're drawn and whether they're double districts. I think Judge Wolf, who was a former Missouri Supreme Court judge, came forward and said, I don't know that we really get into that. That's a legislative issue and they may have to redraft. I think the salient legal issues here are whether they could do this at all. And before we get to the answer on that, the double counting isn't as big of a deal.
Yeah, I know from talking to Judge Wolf about this, he feels very strongly you're only allowed to do this right after you get new census numbers. It feels like that could be persuasive, but depending on the judge.
Depending on the judge and depending on how there's a provision in the state constitution that says it can be done from time to time, sort of a general catch-all that maybe that will sink that argument. I don't know.
Okay. Well, we're going to have a lot to watch as this moves forward. It has a huge impact on what happens to voters in Kansas City. Has a big impact on the career of Emanuel Cleaver, who has served a long time in Congress. I imagine we'll be talking about this next month on the
I would
Legal
note there's
Roundtable.
also the petition process, but they're trying to, that if all the court arguments fail, there's still the referendum they're trying to get through, which I think they'll have a good chance of getting it on the ballot. And
it feels like
the people can do it.
There's even arguments about whether or not they'll be able to get this on the ballot that are going to end up again before a judge.
Sure. But they're always challenging those things.
Yeah, and it always seems to come back to lawyers. That's why all of y'all have good job security. Let's talk about a different matter. This also has something to do with the federal government. Two notorious St. Louis developers had the cases against them dropped. Brothers Sid Chakraverty and Vic Alston had been charged criminally with defrauding a city program. Well, prosecutors said the program had been deemed unconstitutional by the Justice Department. And the brothers, they said, had agreed to repay the cost of the tax breaks. Now, perhaps not coincidentally, the brothers had hired the brother of Attorney General Pam Bondi to represent them. This is Brad Bondi. He's apparently a very good lawyer, but he was brought into this case. But it turns out it was Pam Bondi's underling. This is the U.S. Attorney for the Eastern District, the man running the office himself, Tom Albus, who personally filed the paperwork to dismiss this case. That bypasses Hal Goldsmith, who was the career prosecutor who handled this. Nicole, you used to work in this office. You worked with Hal Goldsmith. What do you make of the fact that it was Tom Albus who filed this dismissal here and not Hal Goldsmith?
Yeah, I mean, just to be clear, I was in the Southern District of Illinois with Hal Goldsmith, but not the Eastern District. But anyway.
Different federal court.
Different federal district, yes. I do think it's an interesting situation when the U.S. attorney comes in and files the dismissal, but it's not unheard of. The U.S. attorney's name is on every single pleading that a U.S. attorney files. Yes, I think there's maybe some politics at play here. I mean, these guys basically defrauded the government. They came in and got all kinds of tax benefits for saying that they were utilizing minority and women-owned businesses, and they actually committed wire fraud and falsified documents in doing so.
Allegedly.
Yes, allegedly. You're right. I should say that. And, that's what they got caught for, and that's what they were indicted for. But then the U.S. attorney came in and dismissed it, saying these programs aren't being run anymore. And, the federal government is saying that these types of programs are unconstitutional. In the past, I'm not sure that would have called for a dismissal, right? Because the alleged fraud, happened. And the indictment says it's more probable than not that it happened. So I don't know that it would have been an automatic dismissal in the past, but here we have it, and it's been dismissed by the U.S. attorney, whose name ultimately goes on the pleading.
So I've heard a lot of laymen talking about this, and they're saying, well, this program was unconstitutional. How can you defraud an unconstitutional program? Booker, is it possible that the program could be unconstitutional? Let's say the Supreme Court would wipe out this program, which didn't happen, but could happen. And that at the same time, somebody could be held criminally liable for violating it.
For sure. Fraud is fraud. And perhaps going forward, some decision will be made ultimately that the program was unconstitutional. But as it stands, and at the time they were charged, there was no question about the constitutionality of the program. So it was just, let us say, unfortunate timing. I know Hal Goldsmith. I know Tom Albus. I know that the line prosecutors were happy to see him appointed as the U.S. attorney there. But yet the way this occurred and the timing of it and the fact that we have a chief executive who is known as being somewhat transactional gives some cause for concern.
Booker has said that in such a polite way. His diplomacy is a great credit to him. Jim, I'm wondering if you'd put it that diplomatically.
Well, I think one thing we've overlooked is, if I'm not mistaken, Hal Goldsmith actually addressed the issue of the constitutionality a few weeks beforehand in a pleading, and very much stated that they still believe that this, despite the fact that these orders deeming these things unconstitutional, that it was still fraud. So I also know Tom Albus. I've always thought of him as a good guy and honest.
He seems to have a very good reputation in town.
And he was a longtime assistant U.S. attorney, and he was very good at his job. He was a judge in the county. But man, the timing here and the appearance of impropriety here is it's just a bad look. I don't know what's in his heart. I don't know his intentions. But when you get appointed as U.S. attorney, and then a few weeks later this happens, it happened in another case in Florida where a case was dismissed with Attorney General Bondi's brother as a lawyer. I mean, just I don't know. It's just a bad look.
I want to bring up something else. Jacob Barker at the St. Louis Post-Dispatch did a really good job with this story. He broke the news about how these charges were being dropped. He also reported on the fact that Tom Albus himself dropped off a check at City Hall. This is the supposed restitution from these developers. They were given tax breaks that were valued at $3 million or so. They repaid $1 million. It was sort of publicly put out there they were going to repay this. Jim, is there any explanation that would say, oh, no, I mean, when we're talking about this, we actually repay 1/3 of the sum. That's how it works.
Maybe there was a miscommunication somewhere. I don't know.
Yeah. Well, and the part about the U.S. attorney personally dropping it off, I can say that part is weird. that is not weird? Okay. That is not how that normally works.
That's interesting. I did not seize on that detail. Who would normally drop off the restitution?
Put it in the mail.
The defendant or the defendant's attorney.
I would not put it in the mail in St. Louis. I'm sorry. I had the Postal Service
wire
here. Okay, wire it, yes. But you're saying, okay, that's odd.
And I think Tom Albus had a quote that he wanted to make sure it got there or something like that. But that's a little out of the ordinary.
Out of the ordinary. I will say this might be why Tom Albus has a good reputation in town. I appreciate somebody who goes and gets work done themselves and doesn't just delegate to an underling. So he was his own courier. And I'm not being sarcastic. I actually respect that side of it.
I think it's a really optimistic way of looking at it. I hope you're right.
We are talking today to our Legal Roundtable. So much to talk about today. And we are joined by attorney Nicole Gorofsky, also Jim Wersch, and former appellate court judge Booker T. Shaw. We're going to take a brief break here. When we come back, we're going to talk about the First Amendment. It feels like it's a little bit under fire. Let's dig into where, how, and why. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha, and I'm in because it is our monthly Legal Roundtable. This happens once a month, always sort of at the end of the month. We talk about what has happened in the previous 4 weeks or so and dig into the news, all the news involving the judicial system. We'll get back to that conversation in just a moment. But first, Missouri Governor Mike Kehoe is dispatching the Missouri National Guard to help support President Donald Trump's immigration enforcement efforts. That is here in Missouri. Starting tomorrow, members of the Guard will assist with administrative, clerical, and logistical duties at immigration and customs enforcement processing facilities. A spokesperson for Kehoe said the move will allow ICE personnel to focus on their core job of enforcement and security. And we will have more on this story at STLPR.org. So just a little breaking news to kick off this conversation. Now back to our monthly Legal Roundtable. And today that includes Booker T. Shaw. He's a former justice on the Missouri Court of Appeals for the Eastern District and a partner at Thompson Coburn. We're also joined by Nicole Gorofsky. She's a former prosecutor and a partner at the Clayton firm Frankel, Rubin, Klein, Payne, and Podlowski. And last but never least, we're joined by Jim Wersch, a former public defender. He's now in private practice at the law firm Kazali Wersch. He specializes in civil rights litigation. So, Jim, civil rights. I feel like that includes the First Amendment. A Palestinian student group was able to march in Mizzou's homecoming parade this past weekend, but only because they filed a lawsuit. The Council on American Islamic Relations filed this suit on behalf of Mizzou's Students for Justice in Palestine. Judge Stephen Bow, is that Bow? Buff? How am I saying that? Bow. Bow. He says they can participate in this homecoming parade as long as they comply with the university's parade policy. So that parade policy, earlier this year, the university updated it to exclude political expression. You can be in this parade, but you can't be saying, we want justice in Palestine, or however you feel about that issue. That sounds neutral on its face. Can they just stop people from any sort of political expression?
I mean, even a public education university can make restrictions, reasonable restrictions on speech under some circumstances. And I think if the judge went through a very detailed opinion, looking at all the different angles. I mean, there's how is the homecoming a speech on behalf of the people participating, or is it a speech of the university? And those are treated differently. And there's lots of different angles, but ultimately I think the court found that what they do in fact do, despite whatever they say in their policy, is offer a variety of different viewpoints. They cited to a sitting congressman who was going to be in the parade, which certainly seems political. And noted that with all these different things there, to discriminate against this one viewpoint was problematic under these circumstances.
Okay, so to say that if you believe in this issue, you can be in this parade, you just can't be there waving a banner about the issue?
Well, no, I think the judge was saying that by excluding them, they were discriminating on their viewpoints, especially when they were inviting so many other viewpoints, and that was wrong. And I guess I don't know the limits. I know they were asking to put some signs up. I don't know if that was limited or not.
I don't know that any of our panel was at this homecoming parade. Nicole?
That's what I was actually going to say. I was looking, after you wanted to talk about this story, then I was looking in the newspaper to see if there was anything about how it actually went. And I didn't see anything. But I think, what's interesting is I was so curious about if I was their attorney for this group that was going to be in the parade, how would I have advised them about how to participate? I mean, I think, look, the First Amendment free speech law says if the government can put restrictions on speech as long as it's narrowly tailored and must serve a significant government interest without being too overly broad or substantially too restrictive. So I think the court found that, look, preventing them from participating at all was too overly broad, right? And but then on the flip side, the order said you can participate, but you have to still follow the university's policies and procedures. Well, the university's policies and procedures say that you can't do political expression. So, rife for, interpretation, right? So I was so curious how this actually went and what they actually said and whether there's going to be any infighting afterwards. But
I kind of guess on that front, no news is good news. Right. It appears there was not major controversy that came out of this parade. Maybe Judge Bao just threaded this needle. But Booker, I think Nicole raises some good questions there. It does seem kind of tricky that I can be there as a group that has a political cause, but I still have to follow this policy that I can't have political expression.
Well, I think ultimately, the judge, I believe, certainly made the right decision here. But ultimately, it's, in the eye of the beholder. And I think as long as it was, quote unquote, not disruptive, then it would have been permitted.
And it sounds like that's probably what happened.
Apparently not, because we heard nothing about it.
So I'm thinking about a political group. What if there was a Nazi student group? I know famously the Nazis were allowed to march in Skokie, Illinois. Could they march in the Mizzou homecoming parade? Nicole?
My brain went to exactly the same thing, right? So I think that pursuant to this order and this judge's reasoning, they would be allowed to march. It depends on what they would say, though. Are they inciting people to violence? Because that would not be okay. And, there's the added complication of the university having their policy and procedures, right, where Skokie, Illinois didn't necessarily have that situation. So that's why I'm so curious to find out, what did they actually say? What did they do? Maybe they were quiet. This I think remains to be seen. It's really interesting.
Could be a moving thing to just march silently, make a point that we're not allowed to speak, but we're still here. I don't know.
Well, I think the name of the organization itself, which I'm assuming they were allowed to display, is
at least have their banner.
It sends a message.
Yeah. Yeah. We are here. This is an issue we care about. Yeah. So speaking of Moon Choi, the system president for the University of Missouri, who was sued in this case involving the Students for Justice in Palestine, he very recently sent guidance to staff in the University of Missouri system, warning, here's a quote, "The university's interest in the efficiency of its operations may outweigh the employees' rights of free expression, and that speech capable of disrupting that efficiency may be grounds for discipline or termination." I hate to ask a super direct question when I know that everything about the law is very complicated, but Booker Shaw, can he just do that? Can he say you could be terminated because of some sort of speech that you're expressing?
Well, it depends, right, as you know. So it does bring to mind the whole, a topic we're going to get to later, the Jimmy Kimmel situation. And to what extent is a statement like this going to create some pressure? Because this is a state institution. And, of course, it could be interpreted as a violation of First Amendment rights. And to what extent is this going to chill an individual's right to maybe say things or do things in their private discussions or activities? So it's a fine line and could be difficult. And we're seeing more of this, of course, right now because institutions are concerned about repercussions. And in some instances, I think rightfully so, concerned about repercussions against their own employees.
Yeah, that's fair. I mean, it can start a firestorm. I now work for a private employer. I'm at St. Louis Magazine. I assume St. Louis Magazine could tell me that their interest in the efficiency of the operations outweigh my rights to free expression, but that it only becomes a little more complicated with this side job that I have. And I should mention the University of Missouri System Board of Curators holds the license for this very radio station. They are giving me the right to speak freely right now. So I respect them for that. But is there a different standard between those two employers, what they're allowed to tell their employees?
Yes. And so that's why I always come back to the basics, which is the First Amendment free speech law. If it's a government entity, it has to be narrowly tailored, and it must be precisely limited to serve a significant governmental interest. So private company would not have that same issue. And so I'm thinking, in my head, I'm thinking the University of Missouri, they have some smart lawyers over there. I'm thinking that this email was drafted to thread that needle exactly. So
that it is narrowly tailored.
It is. I'm thinking it is written to match that law, right? They're wise. So they wrote that email, I think, to say, look, we're saying this because we're narrowly tailoring it, right, to this purpose, but also we're trying to not be overly, restrictive, and then just kind of putting that out there. And that's why I think it wasn't more heavy-handed one way or the other. I think it's sort of shrewd in today's political climate, and I think there's probably some good lawyers over there.
Yeah, and you can't blame Moon Choi for being worried about this. Here's a direct quote from Vice President J.D. Vance. He said, quote, "The First Amendment protects a lot of very ugly speech, but if you celebrate Charlie Kirk's death, you should not be protected from being fired for being a disgusting person. If you are a university professor who benefits from American tax dollars, you should not be celebrating Charlie Kirk's death. And if you are, maybe you should lose your job or your university should face a loss of funding." That, to me, if I'm Moon Choi, I'm going, oh boy, I sure hope my employees shut up.
But I think that's an example of being overly heavy-handed, right? Yes. That's the example of not threading that needle carefully, and that's where the government is overstepping. So I think that's a great example of what I was just saying, of how, one was narrowly tailored and thought out well by lawyer, and one was shoot from the hip and maybe not so good.
Well, okay, so let's say that somebody ends up getting fired from the University of Missouri system for having an absolutely reprehensible thing to say about the death of Charlie Kirk. Could they say, hey, my First Amendment rights were violated by J.D. Vance. I'm going after this because J.D. Vance literally put universities on notice. Would anybody take that case?
No.
No?
I mean, you would be addressing that to the university itself as a public entity. And there are, again, case law on how when they can do that and when they can't, and whether or not it's just creating a disruptive workplace is the main test.
It fits perfectly into the situations we've been dealing with Jimmy Kimmel, because that was a more direct statement towards Jimmy Kimmel, right, where the FCC director came in and said what he said. And so this one's indirect, right? So the University of Missouri president comes in and kind of narrowly tailors it. It's very interesting what's happening with free speech here.
Very interesting is one very diplomatic way to put it. I love the diplomacy of this panel today, yes. But yeah, we sort of mentioned this Jimmy Kimmel situation sort of here, there, and everywhere. We should say ABC suspended this show after Jimmy Kimmel's comments about the death of Charlie Kirk. ABC nationally then restored the show. Some local stations continued the ban for a few more days. That includes the ABC affiliate in St. Louis. And we should say Kimmel is now back on the air in St. Louis as of this past Friday. Are there any First Amendment issues, Jim, do you think, with suspending Jimmy Kimmel?
Well, not from ABC. I think I read a good analysis that said that the actual person who would have the First Amendment issue would be ABC versus the FCC, because the FCC was communicating that to ABC. That Jimmy Kimmel himself, as a private employer of a private company, wouldn't really have a strong claim. But that if ABC wanted to weather the political storm of suing the FCC, they could potentially do that.
Yeah, I think that's exactly right. This is where we're seeing this come in, and ABC is the private employer, right? So Jimmy Kimmel is the employee of a private company. But government impact on ABC, that's absolutely right. What the FCC director said directly had an impact on ABC. Now, our local stations are also private companies, and so their choice to not put the show back on the air, again, it is what it is. But if those private companies wanted to go against the FCC director and say that their free speech was violated, they could do that. Now, it looks like they've chosen not to do that.
Booker, any thoughts on that whole sort of morass of these television affiliates and the corporate company and the late night comedian, and what a mess?
It is a mess, and ultimately I think what it comes down to is to what extent are companies and individuals going to resist these kinds of chilling efforts. And we'll just have to wait and see. But I think ultimately the outcome here was, I think, somewhat changed by people just writing in and protesting, and the amount of pushback there was that made these companies, this ABC and I think Sinclair, ultimately said, well, wait a minute, maybe we're going a little too far here, and we'll bring them back on the air.
Nicole?
These things get easily blurred, too, and I think you sometimes have a guest on here who, falls under the category of, maybe libertarian, those types of rights. His name is Dave Rowland. And so Dave was out there basically saying about these types of things, I don't think the founders ever anticipated that so many private decisions would be inherently dependent on government approval. So basically, the way the government is putting pressure on these private companies is something we really haven't seen so much before. And I think it's a problem. And I think we're in sort of uncharted territory where private employers can do what they want. But now the government is so entrenched in their things where they need approval from the FCC or they need approval from the government to merge their companies. So these things are coming up in ways that they haven't before. And the government, we're finding out, has a lot more influence than maybe it should.
Yeah, I'm glad you mentioned that. Nexstar, which is the parent of Fox 2 and KPLR Channel 11 here, is trying to merge with Tegna. That's the parent of Channel 5. And you had them pulling Kimmel because, of course, they need FCC approval for this merger. You can see why everybody's running a little bit scared.
Well, historically, these agencies were considered to be non-political. And so that is somewhat changed.
Yeah. Again, a very diplomatic way to say it. I'm going to go to the phone lines. Rick is calling from St. Louis. I want to take it back. We were talking about these First Amendment issues. Can Nazis march in Skokie? Rick, hi. You're on St. Louis on the air.
Hi, hello.
Thanks for joining us.
Yeah, so I speak as someone who grew up in Columbia, and I've marched in the parade and been going there for college and everything. But the whole thing of you can't be overtly political in the parade is kind of baloney, I would say, because they've had political candidates for office marching in that parade for years and passing out, vote for me, here's my beliefs. So I don't know what is more overtly political than that, and I just kind of want to call a little baloney on MU.
Well, Rick, it sounds like you're making a good point there. Thank you for that call. Nicole?
Yeah. So I used to live in Columbia. I lived there for about 8 years. So, I used to watch that same parade, and that's true. It's a huge place for political candidates to come out and go in the parade. But I was kind of thinking about that same thought, like what's the deal with them? And then the Palestinian group can't. But I don't see the politicians who are in the parade actually espousing any views. They just run in the parade and sort of, I'm here, vote for me kind of thing, but they don't really express any political views during the parade. So I think that might be the difference. But it is an interesting point the caller brings up.
You make a good point. If they're just there promoting themselves versus they're talking about politics, does that make a difference? It sounds like a lawsuit for another day. And if people have questions for our panel strictly about the matters we're talking about, they are not here to become your lawyer. But you can join our conversation at 314-382-8255. That's 314-382-TALK. We do need to take a quick break, but when we come up next, we're going to talk about Missouri's so-called squatters law. It appears to be under fire. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky in for Elaine Cha, here with our Legal Roundtable, 3 of the smartest attorneys in town helping us make sense of the law and so many things that don't really make sense these days. We're joined by Nicole Gorofsky. She's a former prosecutor. She's now a partner at Frankel, Rubin, Klein, Payne, and Podlowski. We're also joined by Booker T. Shaw. He's a former justice on the Missouri Court of Appeals Eastern District and a partner at Thompson Coburn. And we're joined by Jim Wersch, a former public defender. He's now in private practice at Kazali Wersch. He specializes in civil rights litigation. So the former U.S. Attorney for the Eastern District, Catherine Hanaway, was recently sworn in as the state's Attorney General. This is something I'm unduly proud of. It's the first time that I am aware of that a former panelist on this show has been named the state's top attorney. This is just a testament to the great caliber of panelists we get here. And Catherine always did her homework. She's so smart. I feel really hopeful about her tenure. Now, at her swearing in this past month, she said her focus will be on things like Medicaid fraud, consumer protection, and violent crimes. Booker Shaw, to me, that feels like kind of a change from where we saw Andrew Bailey's focus. Do you think this is something new for an attorney general?
Well, I think Catherine Hanaway, I believe she will be something new. As you have mentioned, I think the entire legal community is very hopeful because so many of us have worked with her before. I know when she was the U.S. Attorney for the Eastern District of Missouri, the staff there, the attorneys, really enjoyed her tenure there, thought very highly of her, still do. I know when she went over to Hush Blackwell, and she was actually chairman of that firm, I worked with her some on issues there, and we've played golf together and such. And she's, as you said, very smart, very rational, not particularly politically motivated. So I think the whole legal community is happy about it. And so we'll see.
It's nice to see a good choice from Governor Kehoe. So she's still very new to this job. We have not yet seen her proactively take on big new things yet. It'll be interesting to see where that goes. But Jim, you were sort of a firsthand witness to something the Attorney General's office was dealing with a couple days ago that I thought, oh, that's kind of a funny anecdote. Certainly doesn't reflect on Catherine Hanaway,
right.
But does reflect on some chaos vis-a-vis the new state board in charge of the St. Louis Police.
Yeah, I'll try to be pithy with it because there's lots of moving parts, but essentially, and this is nothing to do with Catherine Hanaway. This all have to do with the way that the statute was written, taking over the police and the governor's actions. But basically, we had a hearing where the judge was questioning whether the Attorney General's office could even represent a board. The Board of Police Commissioners, because at the time the Board of Police Commissioners didn't exist because the governor had removed them.
And we should say he just had to remove them for like a 2-week period so they could shove through the new congressional map. Right. And he knew that if that appointment was lingering, it could become a major distraction from this map he needed to get through.
Well, they put a provision in the law that said that he could appoint people and that at the next special session or General Assembly, the legislature would have to affirm them. And so that was going to, by law, it would have to come up with that, and they didn't want that as a distraction. So instead, they just removed everyone, and that removed the problem.
No board.
Yeah. But we had, and the problem is, we have lawyers. The Attorney General's office has taken over all of the city litigation, and they don't have any lawyers in St. Louis to handle these things. So all the lawyers are coming from Kansas City, 4 hours away, for these status hearings, and it's just a mess.
That sounds insane.
Yeah.
I mean, if I was Catherine Hanaway, I would be like, what can I do to get rid of having to handle this?
Yeah, hopefully they're going to be staffing up the St. Louis office again with lawyers, but in the meantime, it's been quite a mess.
Nicole, I understand you just happened to be there. This was like a Legal Roundtable reunion happening at the same hearing.
It was, and I was there with a young associate trying to show him the ropes, in state court, and he was, I think, a little of a deer in headlights of what is happening. No one knows who's representing who or who's on first, and it was fascinating. But going back to Catherine Hanaway, I think, is this a new era? I hope so, but it was a new era before this. So the Attorney General's office used to be an office that did things for Missourians. And, in my opinion, we had kind of a shift where we used to call them on this show, I think, even, look, we have the Eric Schmidt special, litigation that was soundbite litigation, I think, for the purpose of these politicians using the office as a stepping stone to get somewhere else, none of them fulfilling their terms. I think it's pretty hopeful that we have Catherine Hanaway coming in who says, look, she's even going to run for Attorney General next time, and that she's hoping to do things for Missourians. Again, the consumer protection, the violent crime, some of those issues that really were a big deal to the Attorney General's office before we got off track. So I'm cautiously optimistic here.
Yeah, we did have a couple in a row that did manage to catch President Trump's eye in a big way. So their strategy worked. Whether it was working for Missourians, that's a different question. And Catherine Hanaway, I think, this is not a woman who needs the attention of the federal government. She's maybe the biggest deal in Missouri, other than the governor. I didn't mean to, to cause friction there. Let's talk about a different matter involving state law. So 2 brothers were evicted from their longtime family home this past month, and their attorney says it shows why a new Missouri law is a bad idea. Missouri's so-called squatters law was signed into law after the pandemic, and to my reading, it basically allows landlords to evict people without any due process. Jim, it's your partner, Javad Kazali, well known to everyone who listens to this show. He got involved in fighting this because it happened to the young men that were living next door to him. But does he have a point here that this thing could be ripe for a legal challenge?
Yes. And just to give a little context, it was, a woman had owned this home for 20 years. She died of cancer. Her kids were living in the home. Someone bought the home and then immediately removed them from the home via this order. And the problem is the statute is designed for squatters. And that means someone who just shows up at a property and won't leave. But they have no prior relationship to the property. They're not tenants. They weren't living in there, with permission. And that's what it's geared to do. And I don't know how much that is a problem in Missouri, but if it is, this is what it was addressed to do.
In some neighborhoods, I know just from being a journalist, it is a problem.
So it's a useful tool to handle that specific situation. The problem is that some landlords are going in and using this tool for tenants who do have a legal right to, and they're specifically carved out as not, that any tenancy protections still remain for those tenants who are properly there. This isn't supposed to be used against them. But the problem is they can go in and get what they call an ex parte order, which basically means one party goes to a judge by themselves and says, I want these people removed. The other side's not there to contest it. All they have to do is fill out a box that says all these things are met, and there's no one there to challenge it. And then suddenly they get an order. A sheriff walks over and kicks these guys out of their house without any attempt to challenge it. And it's just not the vehicle to be used in those types of situations with tenants. They still are protected by landlord-tenant law. They're supposed to get notice. They're supposed to get a hearing. All that stuff. So the real issue is the abuse of the system by some landlords who are using it for the improper purpose. And that because of the design of it, there's no real way to challenge it.
Yeah, I get, what you're saying. Like the law was written to carve out where you're not supposed to use this on your own tenants. But it seems like just inherent in having a law where the other side doesn't get their moment in court, it opens the door to that kind of abuse. Booker, could you see there being some sort of due process type challenge? I was just booted out of this place where I had been a tenant, and because of this law, I had to leave under the very rapid circumstances. Didn't even get to pack my bags.
Well, sure, just kind of kicked out. And of course, this particular case highlights the potential problems in a very graphic way, where there was perhaps some fraud involved. So thankfully, these young men now have an outstanding attorney representing them, and so I expect due process will prevail, and so will justice.
So I was so interested in how did this get started in Missouri, and it turns out this is a law that is happening in a lot of other states. It seems like it might be a national organization encouraging states to do this. Nicole, have you seen legal challenges elsewhere?
Yeah, I think that this has been enacted in other states, and then people are seeing the same situations that we're seeing here, which is abuse of the situation. And I think this is kind of a new legal issue du jour that we're going to see a lot of litigation on in a lot of places, including here. So I do think that there has been a history of squatters. There's even commercials on TV now. If someone comes in and steals your title, and there's all kinds of issues with people misusing property rights. So I think it was maybe a law that was supposed to serve a need, but then the ex parte nature of it, ex parte, like Jim said, means you can come in without the other side knowing about it and get this handled. It's just ripe ripe for, misuse. So, yeah, I think we will see a lot of litigation. It'll be interesting to see if any of these laws survive.
Yeah, I can't wait to get messages from Javad constantly in the next 6 months updating me on his case. I'm going to have to drop everything and cover it. And I probably will. That's the thing about Javad. He's very persuasive. So,
no comment.
Changing gears here. All of us who were in college in the 90s, we knew that Everclear was dangerous. We were warned that this 190 proof grain alcohol could get you blackout drunk. You might never wake up. But now a new lawsuit seeks to ban Everclear not for its intoxicating effects, but its flammability. It was filed on behalf of an international student from Hong Kong. She was apparently at her first ever fraternity party in the United States when somebody very stupidly, we should say, poured Everclear into a fire. And there ended up being this big, the flame poofed out, and it left her with some pretty severe burns. So these lawyers for St. Louis-based Everclear have argued that she doesn't have standing to pursue this suit because it was another person, not the company, that poured Everclear into this fire. They also say she can't argue that she's likely to suffer a similar injury. This was kind of a one-time thing. Nicole, does that mean this lawsuit is dead on arrival?
I don't think so. I think, part of the issue was Everclear apparently knew that this was a tendency with their alcohol, and they used to put a huge warning label on their products saying, look, okay, sometimes we think it's stupid. People should know. Don't pour, grain alcohol on a fire.
You should know that.
You should know that. And I'm a 90s kid myself, so I'm with you on that. But they did used to have this massive warning label. Why they got rid of it, I have no idea. But if they set sort of the standard and then got rid of it, they may have some liability there. They may have voluntarily undertaken a duty to warn people and then pulled it back. And then that gives a legal issue to actually proceed on.
Interesting. So, if you have a big warning label, not a good idea to get smaller? Is that sort of a central tenet of alcohol marketing?
I think so. And I think, one thing it reminds me of is that there's a requirement in Missouri for lawyers to say, advertising is not a reason to have, and it's in the tiniest print on those billboards that you see. So maybe they're taking a cue from us.
Yeah, I don't think any of us are going to try to challenge this. We know the entire legal industry would rise up against us. But in this case, it's this very sad situation here. You can also see a jury saying, hey, caveat emptor, people should know better than to be around booze and flames. Do you think that could be a compelling argument?
It could be. It could also be, like they're saying, this isn't the person who bought the bottle. So, the idiot who did it was the one who should have known not to do it. And if she was just a bystander and she certainly has a claim against the idiot who did it.
And she did file that as well.
But it may be a harder claim to bring against the company, given that she was not the one who was deceived by the marketing.
Oh, okay. That adds a legal wrinkle right
potentially.
There. Interesting.
I think it has a parallel to gun litigation, right? So when someone buys a gun and then goes out and shoots people, we are seeing a new rise in litigation of people suing these gun companies. And I think some of these cases are getting through. Now you sue the shooter too, but some people are suing these gun companies and finding legal pathways to do that. So I think, I think it has a parallel. I don't think it's necessarily automatically dead in the water.
So in our final 2 minutes here, St. Peter's-based Car Shield and the Better Business Bureau have been locked in this 5-year legal battle. Car Shield just won a round of this very lengthy litigation. I find myself thinking of the First Amendment here, Jim. So Car Shield had asked a state court to stop the Better Business Bureau from referencing a $10 million settlement that Car Shield reached last year with the Federal Trade Commission. They said that the Better Business Bureau couldn't do that unless it also published a full response from Car Shield. I'm shocked. The judge says, yeah, you have to publish the full response from Car Shield. I'm going, whoa. A judge can just tell the Better Business Bureau they're not allowed to share information that by all accounts is accurate? What is happening in this country?
Right. I also was surprised when I first read that, but when you dig into the details of it, apparently this is all just a breach of contract case that has nothing to do with the First Amendment.
How is there a breach of contract between the Better Business Bureau and Car Shield?
Because they had previous litigation, and they settled that litigation, and they had a confidential settlement agreement. And part of that was that if the Better Business Bureau ever published certain things, that they had to give a response to Car Shield and publish that with it. And they contractually agreed to do that. And now they were trying to get around that. And the judge said, nope, it's clear as day. You have to do it. and issue the restraining order.
So, Booker Shaw, no First Amendment issues here for me to get wound up about?
No.
That's simple. So this is, contractual law. You can sign away your First Amendment rights.
Yes.
People do it all the time.
100%.
I guess we've all been doing this, and we don't get agitated when we're doing it ourselves, right? Well, Jim, thank you for clearing that up for us. I very much appreciate that. And thank you for joining us on today's Legal Roundtable. We've reached the end of our time here today. Jim Wersch of Khazali Wersch, thank you.
Thank you.
And also Nicole Gorofsky of Frankel, Rubin, Klein, Payne, and Pudlowski. Congrats again on your new job, and thanks so much for joining us.
Thanks for having me.
And Booker T. Shaw, former judge and partner at Thompson Coburn. Thank you so much for joining us.
Thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.